A very good evening, gentlemen. I'm sure that we all had quite an awesome and lovely day. All right, you're welcome to tonight's online session, and I'm still your host, O.O. Stevens. And today we are going to be looking at the topic Charges 2. Charges 2 in criminal litigation. And in Charges 2, we are going to be looking at the concept of a defective charge. We'll be looking at how a defective charge can be amended, and we'll be looking at what is known as post-amendment procedures. Now, defective charge. A charge is said to be defective where it violates the rules of drafting a charge. The rules of drafting a charge, I believe by now we are all aware about the rules against ambiguity, rule against duplicity, rule against misjoinder of offenders, and rule against misjoinder of offenses. So any charge that violates the general principle or the general rule of any of these rules, and also that violates the known exceptions of the rule, such a charge will be said to be defective. And if the defect in the charge sheet is of such nature as to mislead the accused person, then any conviction that is based on it shall be reversed on appeal. I am sure by now we are all aware that the rule against ambiguity is not open to any exception. And we have already given us the acronym of ADPOPVS, ADPOPs, which are what a count is expected to contain. So where the accused person has shown that the information contained in that particular count or the information contained in that particular charge sheet has misled him, and if the appellate court believes him, then that can be a ground for the appellate court to reverse any conviction that is actually gotten on the premise of that defective charge. However, where the accused person is not misled by the defects in the charge sheet, then the validity of the charge sheet shall not be affected. Now, if a charge sheet is defective, an objection to it should be made at the commencement of trial before the accused person enters his plea. In other words, upon the arraignment of an accused person and he is placed in the dock unfettered and the charge has been read to him and he has been asked to take his plea, where he has an objection to the charge sheet upon which he has been arraigned, he is not expected to take a plea. He has to objecting to the nature of that charge sheet, because where he takes his plea, the implication is that he has submitted himself to the jurisdiction of the court, and he cannot afterwards complain because he has been presumed to have waived his right to complain. So if he must raise an objection, the objection is going to be before any plea is taken. But once a plea is taken, the implication is that I have submitted myself to the jurisdiction of the court to be tried on the premise or foundation of this charge sheet, and you cannot wake up tomorrow and say that the charge sheet was defective. Nobody is going to entertain such a complaint from you. Now, if a charge sheet is defective, can it be amended? Yes, it can be amended. Now, a defective charge may be amended at any time before judgment, subject to the leave of the court. So if the prosecution notices that there are some defects in that particular charge sheet, he can amend it. But the amendment of a charge sheet, if it is before the arraignment of the accused, then there is no requirement to seek the leave of the court. But if it's after the accused has been arraigned, then there are some things that the accused wants to that the prosecution wants to maybe add or remove from the charge sheet, then he has to seek the leave of the court before such can happen. Now, however, if the amendment will cause injustice to the accused, then the court will not allow it. If the amendment will cause injustice to the accused, then the court will not allow such an amendment. And the court can also make amendments suo motu. The court can by itself make an amendment on a charge sheet, and such amendment should not be made to give the court jurisdiction where it had none under the original charge. For instance, now, if what is contained on a charge sheet is stealing, we know that magistrate court has jurisdiction to try the offense of stealing. Now, the magistrate cannot amend that charge now to contain the offense of armed robbery. If he contains the offense of armed robbery, he cannot assume jurisdiction because he cannot, by amendment, give himself jurisdiction in a matter that he has no jurisdiction on. That is the implication of that. Now, amendment may take the form of substituting a new charge for an old one. It should be noted, however, that the substituted charge is a continuation of the life of the old defective charge, meaning you can bring a new charge entirely and substitute with the old charge, but make sure that whatever thing that is contained in this new charge is really flowing from the old charge, except the fact that the old charge has some material defects. But make sure that what you are bringing with this new charge is really flowing from the charges that are contained in the old defective charge. In other words, you cannot come and start giving us new offenses. You cannot come and start bringing up new elements and new facts that are not contained in the old charge. When so happens now, then such cannot be allowed. So there has to be a correlation between the new charge and the old charge before the court can actually allow it. Now, after a charge has been amended, are there things expected of the court to do? Yes. And that is called post-amendment procedure. Please, this is an exam area. That is called post-amendment procedure. So immediately there is an amendment, then after the amendment, there has to be a procedure that has to be observed. Now, where a charge is amended by the court, the following procedure must be observed before continuing with the trial. The following procedure must, please, this is an exam area, so note it. The following procedure must be observed before continuing with the trial. Now, the new charge sheet that has been amended is going to be read and explained to the accused all over again. So, meaning that once a charge has been amended, the accused is expected to have it read to him. And now, after it has been read to him, then the accused is going to be called upon to enter a fresh plea. Fresh plea means that he's going to say guilty or not guilty on the premise of that amended charge. Now, when he enters a plea of not guilty, he shall state whether he is ready to be tried on the new charge, but this is for electable offenses. You know, there are some offenses that the magistrate court cannot ordinarily try, but a party can tell the magistrate that he wants him to try it. That is electable offenses. There are some offenses the magistrate cannot ordinarily try, but party can agree and tell the magistrate that he wants him to try for the offense. So if it's an electable offense, then such a party would have to be asked whether he is willing to be tried on the elements of the new charge. Now, if the accused says that he is not ready, the court shall consider his reason, and if proceeding immediately with the trial will not be prejudicial to the accused or the prosecutor, the court may proceed with the trial immediately. So when he says that he's not ready to be tried on the new charge, the court will have to consider if he's a type that the court doesn't even have to ab initio seek for his consent, then the court can just go ahead and continue with the trial, so long as it is shown that continuance with the trial immediately is not going to be prejudicial to the case of the accused. But where it is going to be prejudicial, they may be given an opportunity for adjournment. Adjournment can be made to a later date to enable the accused to prepare for his defense very well. So that is the case. Now, if a charge has been amended, the accused or any of the parties can call or recall witnesses. Assuming now that the amendment took place before after a trial had commenced, then and witnesses had been called, then if a charge has been amended, then you can recall such witnesses, or you can even call fresh witnesses to come and testify on the elements of the new charge. Now, both the prosecutor and the accused person shall be given opportunity to examine, cross-examine, and re-examine the witnesses. I believe by now we know about examination in chief, cross-examination, and re-examination. Now, it is worthy of note that where a defective charge is not amended and the conviction is based on it, which resulted in a miscarriage of justice, such conviction will be set aside on appeal. So once there is a defect in a charge, we said it earlier, and you didn't bother as a prosecution to amend this charge to remove the error, if there was any conviction that has been gained on the elements of that that charge that was not amended, that charge that is defective, then the appellate court can set aside such a conviction. Also, where the amended charge is not read and explained to the accused and a fresh plea is taken, the entire procedure will be null and void. Now, the implication of the absence of post-amendment procedure, which I told you is an exam area, because law school could ask you, what is the effect of the court not observing post-amendment procedure? The effect is when the court didn't observe it, then it is a ground to render the trial and any judgment derived therefrom null and void. So in other words, those things I have outlined, which are the post-amendment procedure, the court must, as a matter of law, do it. If the court did not do it, then there cannot, then any conviction derived therefrom will be set aside. And the accused cannot waive his right to take a plea. The accused cannot say no problem. No. The court must take its time, read the charge again for him. He will officially take a plea, and the court shall record in its book of proceedings that the accused has taken a plea on the element of this fresh charge, and every other thing that has to be observed must be observed. Else, that would amount to a denial of fair hearing, and it can be a ground to set aside the judgment of such a court. Now, the duty to read, explain, and take fresh plea to an amended charge is a mandatory one. It is a mandatory one. I told you it is mandatory. So even the accused cannot waive it. Even the accused cannot waive it. So that duty is mandatory. The accused cannot say, no problem, don't read again, I just know what the charge is. No, he cannot say something like that. He must, as a matter of law, have the charge read to him, and he will take a fresh plea. And remember, I said that absence of post-amendment procedure is a ground to render the trial and any conviction derived therefrom to be null and void. So we are going to be drawing the curtain here, and I'm very sure that our wonderful lecturers are going to associatively deal more with this topic. But remember, our interest is always with respect to law school expectations and also our likely business with them in the examination. Until we meet again, do take good care of yourselves and happy night rest.